Ms. Nadia Samdin.
Mr. Deputy Speaker, sir, I rise in support on the bill. First, I'd like to declare my interest as a board member of SG Her Empowerment, an institution of public character that strives to empower girls and women through community engagements, partnerships, and research, including on the topic of providing more holistic support to those who have faced online harms. So, with this Online Safety Miscellaneous Amendments Bill, Singapore joins the ranks of jurisdictions such as Australia and Germany, which have dedicated laws regulating the online space. The proposed amendments aim to protect Singapore users from harmful online content and move beyond prescriptive statutory compliance towards public accountability. Online platforms can enhance connectivity and access to information for users. During COVID-19, online platforms allowed us to stay in touch and check in on each other. But social media platforms can be all-consuming. For example, when doom scrolling displaces other forms of interactions and feeds on one's insecurities, putting the number of friends and followers you have on display, and subjecting physical appearance to visible likes and comments, sometimes under troll anonymous accounts. For many, it is a tricky place where being yourself is simply not enough, and putting yourself out there may have unwanted consequences. Nearly half of Singaporeans polled by the Sunlight Alliance for Action have personally experienced online harms. These include being cyberbullied, stalked virtually, and befriended by people who have fake identities. Yet over 40% of people affected said that they would not take action as they believe that nothing will come out of it. Recognizing these grim realities, it is important to ensure that regulations are put in place to safeguard the online space as much as we would our physical space. This bill sends a strong signal that the government does not take online harms lightly. That said, I would like to highlight three specific portions where I believe there is room for the bill to be expanded on, and will be addressing potentially sensitive issues such as gender-based online harms and suicide in my speech. First, the amendment tackles online harms in general, but does not specifically address the prevalence of gender-based online harms. The gender element of online safety cannot be ignored. And in fact, the Sunlight Alliance for Action found that 31% of respondents have experienced or witnessed gender-based online harms. And while the bill governs a wide range of actions by online communication services, or OCS, it will not cover communications within private chat groups, such as SMS, and direct messages. Gender-based online harms take many forms, and a significant proportion of these occur in private communication channels. A number of women have shared with me that they have been on the receiving end of lewd or explicit messages. And in 2021, Aware reported that 70% of technology-facilitated sexual violence seen by their sexual assault care center involved image-based sexual abuse. And almost 30% of these cases took place on private message platforms such as WhatsApp and Telegram, which is an increase in percentage from previous years. Now, I recognize that there are significant privacy concerns and logistical challenges in regulating private messaging. Indeed, the UK's proposed online safety bill came under significant fire last year for its heavy-handedness, which would have compelled online intermediaries to proactively access the content of users' private messages. There have been cases of heavy-handed content moderation in other jurisdictions, which can be seen as an overreach and invasion of privacy, causing individuals to lose access to their email and social media accounts, leading to much consternation. However, there is potential for the bill to compel social media giants to share data, such as historical posts and messages, when the user who is a victim of image-based sexual abuse requests it and requires evidence, for example. This is not impossible. For instance, the Personal Data Protection Act already requires organizations to reveal the data they have on platform users, should the users ask for it. In light of this, I would like to ask the Ministry, what factors has it considered in deciding that the current bill will not provide such recourse in covering private messaging channels? Relatedly, I do appreciate that legislation exists to deal with other aspects of gender-based online harm. For example, when Telegram groups have been found to distribute obscene images of women, administrators were charged under the Penal Code, including with distributing obscene material and facilitating the provision of sexual services. Has the government considered streamlining all online-related harms into the Online Safety Bill, rather than relying on sections in the Penal Code and Protection from Harassment Act, placing a burden on victims to show that harm has indeed been inflicted? For instance, Australia's Online Safety Act, which came into effect early this year, replaced a patchwork of online safety legislation to create a more consistent and clearer regulatory framework. Next, more can be done to ensure that minors are protected from hypersexualization or inappropriate content. In Parliament, I've spoken about the needs to educate youths and parents on a safer internet culture. Minors are a vulnerable group who may not understand the way algorithms work to micro-target audiences with tailored messages and content who could be influenced to consume or produce content that is not age-appropriate before they have the ability to fully evaluate the harms and risks of such behavior. Tragically, the case of Molly Russell in the UK is a striking reminder of the very real dangers. In 2017, 14-year-old Molly died by suicide after viewing online content about self-harm on platforms. In the 6 months before her death, it is reported that Molly had saved, liked, or shared 16,300 pieces of content on one platform alone, of which more than 2,100 in total, or 12 a day, were related to suicide, depression, and self-harm. Algorithms had pushed harmful material to her accounts, some of which she had not requested. And the coroner's inquest concluded recently, ruling that harmful social media content contributed to her death in a more than minimal way. While such devastating cases are not common, even one case is one too many, and we must do all we can to prevent such occurrences from happening in Singapore, including imposing appropriate regulations and considering how we can hold the appropriate parties responsible for the content they allow on their platforms, which can also lead to other physical harms, such as eating disorders or self-injury. Sir, I have heard concerned parents debating the merits of confiscating the mobile phones of their children to prevent them from seeing such information. But banning internet access from our youth today is unrealistic, if not impossible. It also fails to educate and empower them. I continue to believe that more can be done to support minors to make informed decisions about internet content, which is age-appropriate for their consumption, and hope that we will continue to evaluate whether age verification is an appropriate measure to be introduced. I note that in the bill there are references to restrictions protecting children of different age groups, and indeed the knowledge of a 13-year-old would differ from that of an 18-year-old. I would be grateful if the ministry could share some examples of age-appropriate restrictions and how these are differentiated. Of course, regulating providers is only one side of the equation. Consumers of online content need to be savvy too, and guardians need to be educated so that they are more aware of the cyber risks that their children are exposed to and feel confident to support minors. MCI has previously pointed to useful resources by the Media Literacy Council, and I hope that more proactive steps are taken to directly reach out to parents and educate them. I look forward to hearing more about the government's future efforts in this area. Lastly, I would like to seek clarification on the definitions of egregious content. One section of the bill lays out the state's enhanced ability to regulate online communication services if they are found to display egregious content, including content advocating suicide or self-harm, physical or sexual violence and terrorism, etc. While I agree it would be appropriate for access to extremely harmful content to be disabled in Singapore, for example, where misinformation outrightly serves to sow discord between different faiths or promote violence and harms, this is only loosely described and illustrated in the bill and consultations. This could be problematic, and I would also wonder whether certain forms of satirical or creative content may be affected. When it comes to regulation in this space, there are no easy answers. I recognize that in the ever-changing online space, egregious content can take many forms, and hence, it might be desirable for legislators to retain some flexibility when defining the parameters. However, in borderline cases, whose standard of egregious content will prevail? Will there be a committee or council to decide on these boundaries? And as the internet develops and new types of content emerge, will a deliberative body be set up to monitor and revise the definition of egregious content? How will such body consult with Singaporeans to shape changes to these definitions to ensure that the standards of egregious content are widely accepted? Mr. Deputy Speaker in Malay, please. Tahun lepas, sebuah tinjauan lucah melibatkan 12 asatiza wanita telah dimuat naik di satu platform sosial. Yang amat menyedihkan lagi, ialah lebih dari 1,000 orang telah mengambil bahagian dalam tinjauan itu. Ini suatu kelakuan yang amat menjijikkan dan telah menghina martabat wanita kita. Ramai wanita bergelut dengan bahaya dalam talian dan ia boleh menyebabkan trauma yang berpanjangan. Selain ini, kita juga telah membaca beberapa kisah di mana gambar dan video wanita, bekas temanita atau bekas isteri dimuat naik di media sosial gara-gara sebagai tindakan balas dendam atau semata-mata sebagai hiburan sahaja. Saya faham buat masa ini kod amalan ini akan hanya merangkumi OCS terkawal yang ditetapkan oleh MCI untuk mempunyai jangkauan atau impak yang ketara di Singapura. Di sini saya ingin bertanya, berapa kerap senarai OCS terkawal akan disemak memandangkan perkembangan aplikasi dan platform media sosial dan betapa cepatnya maklumat dapat bersebar, dan agar sebarang tindakan diambil dengan tegas dan jelas untuk mengurangkan risiko bahaya kepada pengguna Singapura daripada pendedahan kepada kandungan berbahaya dan memaklumkan para pengguna mereka untuk bertanggungjawab atas langkah tersebut. Walaupun kita mungkin tidak dapat menghapuskan segala kandungan bahaya dalam talian, dengan pengenalan rang undang-undang ini dan tanggungjawab lebih besar yang dimainkan oleh platform teknologi, saya berharap kita boleh menjadikan internet suatu tempat yang lebih selamat untuk semua. Namun, undang-undang dan tindakan oleh platform teknologi sahaja tidak cukup. Ibu bapa juga harus mendidik anak-anak tentang adab dan etika yang betul dalam menggunakan internet. Pada masa yang semasa, masyarakat kita, baik lelaki atau wanita, tua atau muda, harus berani untuk membuat laporan sekiranya mereka melihat sebarang kandungan yang berbahaya. Deputy Speaker, sir, the digital landscape is constantly changing and regulations will always be playing catch-up to realities on the ground. The flexibility in the bill demonstrates an awareness of this, allowing legislators room to respond to emerging needs and OCS providers with some leeway in timelines to address cases depending on each circumstance's complexity. Moving forward, it is likely that further amendments may be needed to respond to new developments in the digital space. Any new regulations should be developed as a whole of society effort in consultation with the people and private sectors too. Mr. Deputy Speaker, sir, I support the bill.